Every day in the USA, people find themselves in court.
It is case number 2023 CR 470. James Watts appears as defense counsel. Kevin Holt, separately from his lawyer by Zoom. Brett Sweeney appears for the state of Kansas. This matter comes before the court at this time for pretrial conference with a jury trial setting for next week. What announcement is made at this time, Mr. Watts?
Your Honor, I've spoken with Mr. Sweeney about a possible resolution of this matter. I've spoken with my client about that resolution. It is my understanding my client wishes to accept that resolution. It's my understanding my client would plead guilty to the sole count of the information, possession of methamphetamines. At time of sentencing, Your Honor, the parties do recommend the low box and the appropriate box. We believe it will be presumptive probation, will probably qualify as a Senate Bill 123 candidate.
All right. Mr. Sweeney, I trust Mr. Watts has announced consistently with your understanding as to how this case would be handled?
Yes, Your Honor.
All right. Mr. Holt, importantly, it's the court's understanding that you would be entering a plea of guilty today and accepting conviction for the level 5 drug possession of methamphetamine charge currently before the court. Is that correct?
Yeah.
All right. Mr. Holt, I've got a number of questions I need to ask you regarding the taking of a felony plea. If there is anything asked of you that you do not fully understand, I will give you the opportunity to confer privately with your attorney, Mr. Watts, at any point. Just let the court know if you need that time to get further private advice, okay?
Okay, I understand.
And I will ask you to speak up when you give your responses to the court's questions. I want to make sure our record is complete and that each participant on the meeting can hear all your responses to the court's question, all right?
Okay,
State your full legal name for the record.
Kevin Scott Holt,
And how old are you right now?
46,
What's the highest level of education that you've attained?
and 11th grade.
Do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this afternoon?
No,
Have you ever been adjudged to be mentally ill?
nope,
Are you currently under the influence of alcohol or any drug?
nope,
Are you currently taking any type of prescription medication?
nope,
Are you supposed to be taking mental health medication that you are not currently taking?
no,
So as you participate today, Mr. Holt, is your mind clear? And do you have a full understanding of what's going on in court?
yes,
Did you receive a copy of the charging document in the case?
I don't think so.
Okay.
No.
All right. Let me ask you, do you understand the nature of the charge of possession of methamphetamine?
Yeah,
Okay. You further understand that when you enter a plea of guilty, you are admitting that very act that's been charged by the state.
yeah,
You also understand that when you enter a plea of guilty, you give up any legal defenses that you might have had to that charge.
yep,
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses at your trial with the assistance of your lawyer, Mr. Watts, and that you could present evidence at the trial on your own behalf and subpoena your own witnesses to court?
yeah, I understand.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case if you wanted to, at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yeah,
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described.
yep, I
Are you
understand.
also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yeah, I understand.
Well, do you understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yeah,
You understand that you have a right to appeal a guilty verdict if you have a trial?
yeah,
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea.
yeah, I understand. Gotcha.
Okay. Now, Mr. Holt, do you understand the possible sentence that you could receive as a result of this guilty plea that you're attempting to make?
Yeah.
Okay, well, we're
Yeah.
going to go over those possible penalties. On the level 4 drug line, in the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. However, in the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. Mr. Holt, as we participate today, we do not know with absolute certainty what your criminal history is. You, better than anyone else here, should know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of that research, as of the date of your sentencing, that determines where you fall along the level 5 drug line, and then you'll be sentenced accordingly. Do you understand that?
Mm-hmm.
I didn't hear the response.
Yeah, I hear you.
Okay. Categories E through I are presumptive probation. If you have a person felony on your record at time of sentencing, you would be presumptive prison in this case. Do you understand that?
Uh-huh.
Is that yes?
Yeah, I hear you.
Yeah, and I will need you to answer yes or no clearly
Oh.
and not give a mumbled response. Okay, Mr. Holt?
Okay, sorry.
All right. You also could receive up to a $100,000 fine for this offense. Do you understand that?
Yes.
All right. Now, Mr. Holt, did your attorney talk over with you this concept that we in the legal profession often refer to as Senate Bill 123?
I'm not sure exactly what it was about.
Okay.
Didn't
You
mention
very
it.
well may qualify for a mandatory drug treatment program. There's certain factors that have to be taken care of and prerequisites to it, but you could very well fall into a category where you would mandatorily be required to participate in a state-sponsored drug treatment program for up to 18 months. Do you understand that?
Okay. Yes.
All right. In addition to any fine that could be imposed, Mr. Holt, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also realize that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Okay.
All right, Mr. Holt, do you understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances? Do you understand that?
Yes.
You understand that, Mr. Holt, that the Kansas Sentencing Guidelines Act is much more than the grid page that I referred to earlier. It's an entire book of sentencing rules and laws. Do you understand that if there are any special rules that apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes.
Have you had an ample opportunity to fully discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Yeah, I think so.
You want any more time with him privately now before we go further?
Maybe. Yeah, I think I do. I want to talk to him about something. But
Okay.
what you said.
All right, then we're going to pause this plea proceeding for a moment.
Okay.
And we're going to set up a breakout session between Mr. Holt and Mr. Watts. Join the session and talk to your attorney, and then we'll come back to this public meeting. Okay, Mr. Holt?
Okay. Okay.
All right. We're ready to go again, gentlemen?
Yes, sir.
Yeah.
Okay, if we can go ahead and resume recording and broadcasting. I think we have that now, so we will continue this plea hearing at this time. All right, Mr. Holt, you had a breakout session with your attorney, Mr. Watts. Are you prepared to go ahead further with this plea hearing?
Yes, please.
All right. Now, let me ask you then, have you had an ample opportunity to fully discuss your legal matters with your attorney, James Watts?
Yes.
Are you satisfied with the services and advice given to you by your attorney?
Yes.
Now, this guilty plea that you're attempting to make, is it being based upon any threat or promises as to what this court will do in regards to your sentence or any other
No.
type of threat or promise?
Nope.
Okay. Mr. Holt, was there anything else that you thought was a specific part of this plea agreement that hasn't been discussed on the record already?
Nope.
You understand that if there are any plea deals between your counsel and the county attorney's office, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
So let me ask you formally, how do you plead to the charge in count 1, possession of methamphetamine, a level 5 drug felony?
I guess guilty.
I'm sorry, what did you say before that?
Guilty.
Okay. And then let me ask you about this. Let's see what happened. According to the state's charging document, Mr. Holt, this took place on or about February 28 of 2023. Is that when it happened?
Yeah.
It happened somewhere in Butler County, Kansas. Where was it?
On the turnpike.
I'm sorry?
On the turnpike.
Oh, on the turnpike. But it was on the turnpike portion of Butler County. Is that
Yeah.
correct?
Yes.
Okay. And on that date, it's alleged by the state that you were in possession of the controlled substance methamphetamine. Were you?
Yeah. Like so.
Where was the methamphetamine?
In my pocket. It fell in my pocket.
And you knew it was there.
Yeah.
And you knew it was methamphetamine.
Yeah.
Okay. So do you now freely, knowingly, and voluntarily enter a plea of guilty and
Yes.
accept conviction for count 1, possession of methamphetamine, a level 5 drug felony?
Yep.
Mr. Watts, do you know of any legal reason why the court shouldn't accept your client's plea?
I do not, Your Honor.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Kevin Holt, are you aware of a legal reason or any other good reason why the court shouldn't accept your guilty plea here today?
I think we're done.
All right. Court will accept Kevin Holt's guilty plea and finds that that plea is made voluntarily. He has an understanding of the nature of the charge against him and the consequences of the plea, and a factual basis for the charge does exist. The court finds the defendant guilty and adjudges him therefore convicted of the level 5 drug felony crime of possession of methamphetamine. It does appear to be the only charge of his charging document. So the court will order a pre-sentence report be completed to accurately determine the defendant's criminal history, and the court will set an appropriate date for sentencing. We're still allowing about 8 weeks, 2 months or so. I will look for a mid-May date, counsel. Mr. Watts, would you be free at 11 o'clock a.m. on Friday, May the 9th?
At 11 o'clock, yes, sir.
Okay. Trusting that works for the state, Mr. Sweeney.
It does, Your Honor. Thank you.
I will set the Kevin Holt sentencing for Friday, May the 9th at 11 o'clock a.m. Mr. Holt, I'm going to order you to appear at the Butler County Judicial Center in El Dorado, Kansas at that time.
Okay.
Even though this is contemplated to be a Zoom proceeding, I'll want you to participate from the Judicial Center's Zoom location. Court security will get you set up in an appropriate location, all right?
Okay.
But I don't want you appearing anywhere else. So Mr. Holt will be at the Judicial Center Friday, May 9th at 11 o'clock. I will order Mr. Holt, as a condition of his continuing bond, to participate fully in the pre-sentence assessments which are necessary. Mr. Holt, you're going to be asked to do a series of assessments, to say the least. One will be a risk needs assessment. Another will be connected with substance abuse. So you'll need to make sure that those steps are followed so that there's no delays in your sentencing, because if you drag your feet and you don't get these things done and we have to delay sentencing, I'll hold you accountable for that.
Okay.
So I want you to contact the Butler County Court Services Department just as soon as we get done here, and then you can start following their direction about what you need to do to get the pre-sentence investigation and report process completed.
Okay.
You have that number, Mr. Holt?
No, I don't.
Yes, sir.
Watts is nodding. I think he's called that number once or twice, I think.
What was the last four?
That'll be Butler County Court Services, the probation department. And just follow whatever direction that office gives about what you need to do next. Okay, Mr. Holt?
Okay.
All right, Mr. Watts, is there anything further we need to address regarding Kevin Scott Holt's case?
I don't believe so, Your Honor. Mr. Holt, call that number today,
I will.
As
please.
soon as we get done here would be best, Mr. Holt.
Okay.
Mr. Sweeney, anything else from the state's perspective?
No, Your Honor.
Very well. Thank you all for your timely appearances here today. It's case number 2023 CR 470. James Watts appears as defense counsel. Defendant, Mr. Holt, appears from the court security Zoom location at the Butler County Judicial Center. Darren DeVinny appears as Butler County attorney. This matter comes before the court at this time for sentencing. The court's docket notes indicate that on March the 11th of 2025, defendant pled guilty to count 1, possession of methamphetamine, a level 5 drug felony. A pre-sentence report was ordered. Defendant was ordered to comply with assessments, and sentencing was set for today. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on the meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history stated therein?
No, Your Honor.
Any objection by the defense, Mr. Watts?
Your Honor, I have reviewed same with my client. We believe it is correct, have no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed further accordingly. Mr. DeVinny, do you know of any legal reason why sentence should not be pronounced in the Holt case at this time?
Your Honor, I did receive communication, it looks like on Monday from Ms. Morgan saying that the full substance abuse assessment had not been received, but the referral had been submitted to community corrections. So I don't know if that's any issue, and really that's a question I have more for Mr. Watts at this point as to whether or not if he has any objection to us proceeding without that in hand.
Mr. Watts?
Well, Judge, I have the SASE in front of me, which indicates a high probability for purposes of qualifying for Senate Bill 123, which is for our purposes here today. It seems that's satisfactory. He scores, as he put it, as we would know, as appropriate place on the grid, a G on the grid, a high risk under the LSCMI, and a high likelihood of a substance abuse disorder. Those things would seem to place him in Senate Bill 123. As to the details of what his treatment program would be, whether that be inpatient or outpatient, I think we'll leave that to community corrections and further assessment.
The court concurs with Mr. Watts' analysis in this case. The court has sufficient information before it to be able to proceed with sentencing in this case, and the court will proceed further on that basis. And I trust, Mr. Watts, you're not aware of any other legal reason why sentence should not be pronounced in this case this morning?
No, sir.
All right. I'll ask Mr. Holt, are you aware of any legal reason or any other good reason why the court shouldn't proceed further with your sentencing here today?
No, I don't see no reason.
I'm sorry, I didn't hear you respond.
No.
Okay, thank you. Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
All right, court will proceed further. I'll ask if there are any victims or members of a victim's family who desires to address the court in relation to this sentencing. Finding none, court at this time will ask for recommendations from counsel regarding an appropriate sentence, beginning with Darren DeVinny on behalf of the state.
Your Honor, my understanding is on this case that we've worked out in this plea, or at least the recommendations here, but the PSI reflects that the primary count is a non-person level 5 drug felony. It is presumptive probation. It's a Senate Bill 123 application with a 20% good time credit. It is sorry, I'm looking here. It looks like a 12-month post-release supervision would be the underlying, or I'm sorry, the post-release probation up to 18 months. But again, I think this meets the Senate Bill 123 recommendations here. There is a matter of There's court-appointed counsel fees to be addressed by the court. I believe the community corrections would be the appropriate level of supervision here, and the alcohol drug evaluation, we've already kind of touched upon that as well. As far as the other costs that would be associated with this case, there'd be a $400 KBI lab fee, $193 in court costs, community corrections fee of $125, supervision fee of $120, Senate Bill 123 assessment fee of $175, Senate Bill 123 offender reimbursement for $125. The total of the cost then being $1,138 in this matter. I think that's an overview really of the recommendations here, but I think that those are the I think that details this case again to the best of my ability. If there was any other communications with Mr. Sweeney that Mr. Watts would have had with regard to sentencing, I'll defer to Mr. Watts.
All right, thank you, Mr. Devaney. Mr. Watts, your recommendations regarding an appropriate sentence?
Your Honor, I would note that, and my notes reflect on March 10 at a phone call to Mr. Sweeney. And of course, we took the plea the following day on the 11th. The state would recommend the mitigated, the low end of the box. We would recommend that low end of the box of 14 months underlying.
Yes.
With the good time and post-release and probation as noted by the state. Judge, I don't know that I have a whole lot else to add. The usual costs and fees that are associated with, there is a KBI lab report, so that would have to be assessed. I don't know that I have anything else to add, Your Honor. It's a pretty, not say a case is routine, but it's falls squarely within the Senate Bill 123 parameters.
Your fees and the representation of this client?
Judge, this would be billed to bids at $1,100.
Know anything about your client's financial circumstances, Mr. Watts?
Your Honor, I think we'll have to inquire of Mr. Holt.
Mr. Holt, can you provide information as to how you currently make your income?
I started working for Elon Musk lately.
How much money do you make?
I don't know yet. I haven't started yet.
All right. Mr. Holt, I'll ask you personally, do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court?
No.
We're now sentencing the case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, which the defendant has a criminal history score of G, thus placing him in grid box 5 drug G. The court hereby sentenced the defendant to a term of 14 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court declines to impose a fine in this particular case. The court does find that the combination in this case of a high risk score on his risk needs assessment with the finding on the SASE of a high probability of a substance abuse disorder indicate that this is a mandatory case for Senate Bill 123. This defendant is ordered to be on probation with community corrections for up to 18 months and complete an approved Senate Bill 123 treatment program, including any aftercare recommendations, which are recommended by his provider. He is to complete a formal substance abuse assessment as directed by community corrections early in his probationary term. Court will want that scheduled and completed within 30 days of today's date. The defendant shall not possess or consume alcohol or illegal drugs while on probation. At his probation officer's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform any community service work that program requires, gain and maintain employment suitably throughout his probationary term, notify his probation officer of any changes in employment status, residence, telephone number, or email address within 24 hours of any such change taking place. He shall abide by any curfew or travel restrictions associated with the program. He's to avoid disreputable characters and places, not have in his possession firearms or dangerous weapons, follow standard conditions of probation and community corrections placement, and make monthly payments in a manner acceptable to the court. Community Corrections is also authorized to require this defendant to meaningfully participate in the MRT program. Court will be assessing $400 restitution to the KBI laboratory, assess a $193 docket fee, $125 community corrections fee, a correctional supervision fee of $120, $300 in Senate bill reimbursement costs, and a bids application fee of $100. I will waive any remainder on fees, given Mr. Holt's current financial circumstances. Court believes that if the court sets up a payment plan on a monthly basis, it shouldn't work a burden or hardship on this defendant. Beginning with the calendar month of June, Mr. Holt, I'm going to require you to pay $100 a month minimum on these amounts.
Okay.
Again, starting with the calendar month of June and every subsequent month until your case is paid in full. The sooner you get it paid off, frankly, the better. So you can pay aggressively if your financial circumstances allow. This is one of those cases where the court often considers jail time as a condition of probation. There's several reasons for that, Mr. Holt. Number one, this isn't your first go around with a felony drug conviction. So whatever happened last time wasn't sufficient to get your attention. Second of all, you did not serve any jail time as a pretrial detainee in this case. Your face sheet shows 0 jail time credit days. You apparently bonded right out and have never been in jail on this case. But the court's not going to do that in your instance, Mr. Holt. And I think the primary motivation for the court is that you've done exactly what the court asked you to do following your plea. You took care of your assessments. We didn't have any delays. As far as I know, there were no problems in that regard. And you showed up at the location where I told you to show up for sentencing on time. You would be surprised, Mr. Holt, about how many people can't follow those simple directions, but you can, which tells me that perhaps you're ready to go right into a probation program and be successful in it. I just hope that your willingness to comply with rules and directives lasts through your probation period as well. And I do need to point out to you that the focal point of your probation and the reason why you're not being incarcerated is because the legislature believes you should get treatment, that you should address a drug problem. And so your drug treatment program is extremely important. So if you'll finish any assessments that are necessary very, very promptly and get started, I see no reason why you can't be 100% successful on this probation period.
Okay.
All right. Some additional orders are necessary and directives. Mr. Holt, you do have the right to seek expungement of these offenses in the future. Certain statutory limitations do apply. You have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have a right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there are prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Mr. Devaney, I'm looking at my notes from this sentencing. I am not aware that there is another sentencing related matter that I need to address. Are you aware of anything?
I just, for my clarification on the journal entry, we are not charging the defendant for the attorney fees Mr. Watts has calculated?
I'm waiving the bids attorney fees portion.
Very well. That's the only thing I had, Your Honor.
All right. Mr. Watts, are you aware of anything further that the court needs to address?
No, sir, thank you.
Mr. Holt, you have any questions about the court sentencing orders?
No.
All right, I have Ken Klossing here from Community Corrections. Mr. Klossing, what direction would you give Mr. Holt?
It's up to Your Honor. He can either call our office, or if you're allowed a breakout room, I can talk to him after this meeting.
Let's go ahead and just keep the meeting open so that you can converse with Mr. Holt and give him further direction regarding his reporting and other requirements on community corrections. So after we recess, Mr. Holt, stay on the Zoom meeting. We'll put you in a session with Mr. Klossing, and he'll talk to you for a few minutes, okay?
Okay.
All right.
Thank you, Your Honor.
If there's nothing further, then the court will recess the court proceedings at this time, but we'll leave the Zoom meeting open for a Klossing and Mr. Holt conference.